Good afternoon, everybody. My name is Khandi Sokoni with Grossman, Young and Hammond, and myself and my colleague Meg Hobbins will be presenting this webinar titled Preserving Permanent Residence. And unlike US, just by way of introduction, we find ourselves in very difficult and strange times with the pandemic. Some of these issues that we're going to review with you apply regardless of the pandemic, but they've been particularly exacerbated by the pandemic. So unlike US citizens, legal permanent residents risk losing their permanent resident status if they do not physically reside in the US for a certain period of time in any given year. There is a distinction between preserving status for purposes of re-entering the country after traveling abroad, and preserving status for purposes of maintaining eligibility to naturalize to US citizenship. So in this webinar, we will address the hard and fast rules on permanent residence and offer some strategies to avoid jeopardizing your green card status. Like I mentioned earlier, the COVID pandemic has presented extra challenges for green card holders because the duration of absence and restrictions on travel have for the most part been out of the control of individuals. So I'll turn it over to Meg Hobbins to get started with outlining for us what are the rules.
Great, thank you so much, Khandi. As Khandi mentioned, my name is Meg Hobbins. I'm a partner at Grossman, Young and Hammond. And I'm thrilled to see some current clients, former clients, and colleagues registered for this topic today. You know, permanent residence is not the most accurate term. As Khandi mentioned, permanent residence isn't permanent. It is a privilege that can be revoked. And understanding the rules, the black and white rules and sort of the gray, more ambiguous rules is really important. And this is definitely a confusing topic, and our goal today is for everybody to walk away with a clear idea of how to issue spot, how to anticipate trouble, and if you are in a situation where residency is at risk, how to understand different remedies. So to start with the rules, the first black and white rule that is a commonly understood one is that a permanent resident card is not valid after someone has been outside of the United States for a year or more. Now, of course, because it's immigration law, there's always exceptions. So there are exceptions for US military and crewmen. And there's also an exception if someone has a valid reentry permit. And we're gonna cover reentry permits later in this presentation. But essentially, if you are outside of the US and your stay abroad is extended and you've been gone for over a year, you will not be able to re-enter on that permanent resident card. So another black and white rule. So individuals who are permanent residents, they have a privileged status. So somewhere in between the status of a US citizen, who should be able to re-enter without issue, and a foreign national with a visa, like a non-immigrant visa. So permanent residents are considered in a special category, but that privileged status can be taken away under certain circumstances. So if a permanent resident has been abroad for over 180 days, they will not get the same privileged return status and be considered automatically a returning resident. They're basically subjecting themselves to increased scrutiny if they've been gone for over 180 days. And the Customs and Border Protection Officer can basically assess them under the different grounds of inadmissibility, essentially question whether or not that person has valid permanent residence. So that's the second black and white rule. So to review, the permanent resident card or green card is not a valid travel document for reentry after being abroad for a 1-year period. And number two, if a permanent resident has been out of the US for over 180 days, also without a reentry permit, then they have fewer rights and their residency can be scrutinized upon reentry. So those are our two black and white rules. And when I'm talking to clients, I feel like those are the two rules that people are most familiar with. And they often think they're the only rules. And that if you meet those basic requirements, you always re-enter on day 179, then you're not going to have any problem returning as a permanent resident. Unfortunately, that's not true because there's also a gray rule, and these two different rules are in section 1018 13C of the Immigration and Nationality Act. So the gray rule is that an immigration officer can make a subjective assessment of whether someone has abandoned or relinquished their status when that person's trying to re-enter. That is as vague as it sounds. There's a huge amount of discretion there. And essentially it gives a CBP officer at any port of entry the authority to really look at the different facts in someone's travel history, how long they've been gone, where they're employed, where their family's located, and make an assessment that they have potentially abandoned. So if we take the example of someone who is satisfying the black and white rules, so someone who is, let's say, has a home in the UK and always returns, they live there, they work there, they have their permanent resident card, but they're really based in the UK, but they always come back, right before the 6-month mark at 178, 179 days. And then spend a week in the US and then depart again and go back to the UK. So that does tick off the requirements for the 1 year and the 6-month rules, but that person will eventually get ensnared with Customs and Border Protection because they have the authority under this other section of the law to make a determination that they've abandoned their residence, looking at the totality of their circumstances. This means that you really do have to do a more holistic assessment of maintaining residence and making sure those ties are in place, or that you are preparing and potentially applying for a reentry permit.
Thank you very much, Meg. So having covered the rules, I guess the next step is to look at what are the remedies when a permanent resident needs to spend a significant time outside of the US. And, like Meg very eloquently covered the fact that it's not enough to just to be meeting the letter of the rule. I think you get the gist of it. Your intention is also really important. They can see through the technical compliance with the rules and get to whether you truly intend to make the US your permanent residence. So what happens if we'll distinguish between an unplanned absence and a planned one. So let's take, for instance, someone who is leaving the United States and knows ahead of time before they leave that they're likely to be outside of the country for a prolonged period of time, maybe 8 months, possibly even a year and a half. What are your options then? What are your remedies? You can file an application for a re-entry permit. So that's a re-entry permit. It's the travel document that you will then present to CPB, to the Customs and Border Protection, upon your entry back to the US after this prolonged absence. When should you take care of this? You must file your re-entry permit prior to departing the US. So you must be physically present in the United States at the time that you file the application on Form I-131. It's actually the same application that people, when you were applying for your green card, you might have been familiar with us filing a 131 for you because we use the same document to apply for advanced parole. You can also, there's sections that you fill out to apply for a re-entry permit. Now, once you file the application for a re-entry permit, the next procedural step after your application is filed is that USCIS is going to call you to take your biometrics, the fingerprints, scanning your eyes. So the biometrics that you go to a USCIS office to do. Biometrics have to be taken in the United States. And therefore, sometimes people will face a challenge if they come and file their application for a reentry permit right before they're leaving. Then the issue is what happens if in a month or two, I get the notice for biometrics. Just keep in mind, you absolutely have to take your biometrics in the United States. Once the reentry permit is subsequently approved, you can make provision on the application to ask that this document be sent to you to a location outside of the US. You could pick it up from a consulate abroad. You could pick it up if you already have an address that you'll be at abroad. You can have it, you can have actually, I'm not so sure that they would made it to an address abroad, but you certainly can pick it up from the consulate outside of the United States. But biometrics have to be taken while you are here. So for some people, what happens is if your time is tight and you can't wait to do biometrics, you file the application before you leave, you go. Once the biometrics is scheduled, you either have to come back. In some instances, depending on your ability to get to a US territory, for instance, if you're in Australia and you can make it to Guam very conveniently, we can always reschedule your biometrics at least once and see if you can get an appointment at a location outside, away from mainland US, but it has to be in the United States.
Great. And Khandi, if I can just jump in, I think that, the reentry permit is a really helpful remedy. I just wanted to touch on some of the logistical challenges with the reentry permit, because it's non-renewable. So that means that you have to keep applying for new reentry permits and essentially prove with each application that you do have this temporary need to be abroad. So there's having to repeat this process every 2 years and then every 1 year is it's pretty onerous for people who are going to be abroad for several years.
Thank you. So that's one option, the reentry permit, but that's only an option if you knew ahead of time that you'd be gone for a long period of time. Just a side note, this is actually an aside, we do want to make sure we point out that you may want to file a reentry permit which allows you to re-enter, but issues associated with re-entering the US are very different from issues associated with trying to preserve your physical presence for purposes of naturalizing. Those are two separate issues. I'll get to them in the next slide. But just so you know, there is an option to file. If at the time you're filing the reentry permit, if naturalizing to US citizenship is something you're thinking about, at the same time, you probably should be considering whether you are eligible. Not everyone's eligible, it's very narrow, but depending on your personal circumstances, you might be eligible to file an N-470, an application to preserve your continuous residence for purposes of naturalizing. But this is only available to people who will be employed abroad with the US government or with the US Research Institute. Certain US corporations are eligible and certain international organizations, if you're working for a UN organization such or the World Bank, IMF, those are entities that make you eligible for an N-470. But let's go into more detail on the next slide.
So Khandi, before we go on to that, if we can just spend a couple more minutes on the reentry permit. Sure. I feel like clients frequently want to understand how long they can stay on a reentry permit. And we've talked about sort of, they're initially granted for a 2-year period. And there's some exceptions to that for professional athletes and people who are members of working for public international organizations. But for the most people, the first one will be a 2-year reentry permit. Once you've been outside of the US for 4 of the last 5 years, then the reentry permit can only be issued in 1-year increments with those certain exceptions for athletes and public international organizations. So this is, like I said before, it really does become pretty challenging if you are in that 1-year increment zone to be reapplying each year. So after you've filed and gone through biometrics, you're really just going to have, you're going to have a few months of reentry permit validity before you're going to have to restart the process. So if you are able to sort of continue with this logistical challenges. I mean, some people can hold on to reentry permits, subsequent reentry permits for several years. But ideally, you're talking about a relatively contained period of time, 2, 3, 4, 5 years. And it really does becomes self-limiting because of the difficulty of coming back, applying, returning for biometrics, and then starting the application process over to get a new one. So people tend to not really consider this a long-term solution for having, employment or family obligations abroad.
Okay, so that's certainly an option where the absence is planned, but then we do have situations like, was the case, I think, in a lot of cases as a result of the pandemic, which is where people traveled and then we're not particularly expecting to be gone for too long, certainly not expecting to be gone for 6 months or longer, and they were. So Meg, could you cover for us what are the remedies when the absence is not planned and you end up finding yourself unexpectedly out of the United States for a prolonged period of time?
Yeah, absolutely. So, the returning resident visa is not usually a hot topic. Some people do fall into the situation where they're abroad for longer than they intended, didn't apply for a reentry permit, and now it's been over a year, and their green card is no longer valid as a travel document to return. With the pandemic, we are seeing this a lot. People are traveled in maybe January or February of this year, and then couldn't return, flights canceled, borders closed, intense concerns about just the health risks of flying back. And so I feel like there's a lot more people who are asking questions about the returning resident visa, what it is, how can you get it? So essentially, when someone is in a situation where their green card is no longer valid, instead of just, you may not even be able to board a flight because the airline may not board you with an expired or with a green card in that situation. And so this is a process by which you can apply for a special visa, the SB1 visa, at the U.S. consulate or embassy, and prove to the consular officer that you were a permanent resident at the time of departure, that you maintained a continuous intent to return to the United States the entire period that you were abroad, and that your trip abroad was genuinely temporary, but was extended by reasons beyond your control and for which you are not responsible. So those are the really key points. And again, I feel like the pandemic is going to open up a lot of compelling arguments that somebody may have been abroad for reasons, initially it was planned to be a temporary trip, but then they couldn't return because of all of these different things that are making travel so difficult. So we've been doing quite a few consultations lately for people who are interested in SB1 visas. Maybe they've been out for 10 months and know they need to return either immediately, or they're going to really have to they're just going to have to wait and then apply for the returning resident visa. So it's an interesting process. It's a two-step process. The first step is to submit a form DS-117. And if you're interested and sort of want to make these different criteria more concrete, if you look at the DS-117, the form really tracks these 3 criteria. So they're having you list your biographic information, list the statistics for your trip. How long were you gone? Where did you go? Why did you travel? And then why did you not return when you planned? They also have you list all of your past trips since becoming a permanent resident to do sort of an overall assessment of your ties. So the first step is to submit this DS-117 and include evidence of the temporary nature of your trip and the fact that it was prolonged for reasons outside of your control. Once that is approved, then you essentially move on to step 2. And step 2 is really kind of following the normal immigrant visa process. So submission of a DS-260, the online immigrant visa application, undergoing a medical examination, and then going to a consular interview. So unfortunately, it is sort of a burdensome process, just like the immigrant visa process. If those of you who are clients who initially got green cards through consular processing know sort of the different steps with that, and that it can be a little bit clunky and time consuming. Same thing for the SB1 visa. So you're essentially reassessed in terms of your admissibility, and then you are provided a immigrant visa to return, the SB1 visa.
And if I could add, Meg, just a side note on the SB1 visa. On occasion, I've run into a situation where the green card, the adult green card holder is here, but maybe the child went to, stayed outside longer to stay with the grandparents while the parents were dealing with something here in the United States. Just keep in mind that the intention of the parents is attributed to the children. So if kids end up needing an SB1 visa because they were gone for too long, it's less of an issue. You still have to go through all those steps to get that SB1 visa for the kid to return, but the intention of the parents, if the parents were here, instead is attributed to the kids. Thank you so much for covering that on what the options are when the absence is unexpected. So I said earlier, we would like to highlight for you the difference between maintaining permanent residence for purposes of reentry issues, and then distinguishing that from how that could impact your eligibility for naturalization. So I should just mention the reentry permit that we just covered pretty extensively. It helps you with the logistics of returning to the United States. But I would like to caution people, if you're already eligible for naturalization, if you think you might be eligible to naturalize to US citizenship, and if that's something that you are considering or thinking about, and there's a possibility you may be stuck outside the country for a long period of time, I would strongly recommend that you review whether it's time to naturalize. Of course, there are lots of permanent residents who, for very good reason, don't want to naturalize, but if it's a possibility for you or it's something you're thinking about, it's something you should seriously consider before the extended travel abroad, because the reentry permit, assuming you're able to get it successfully, only assists you with the logistics of reentering. If you seek to naturalize to US citizenship, you have to meet certain eligibility criteria. Physical presence in the United States is just one of many. So, you have to show good moral character. You have to be above the age of 18. You have to, in terms of showing good moral character, no convictions in the last 5 years. There's a whole list of things that you do have to show. But a very important aspect of your eligibility to naturalize to US citizenship is how long you have been physically present in the United States. For some people, you have to have been a legal permanent resident for 5 years. If you're married to the United States, to a US citizen, it's 3. And then you also have to have been physically present in the United States from the time of your application. You have to have been physically present for a continuous period, for half that time, a continuous period of half of that time. So if you're qualifying on the 5-year criteria, that means, which is 60 months, you have to have been here for 30 months. And if you're qualifying on the basis of 36 months, which is 3 years, then you have to have been here for 18 months. So clearly you can see that if you ended up being outside of the country for a prolonged period of time, let's say you were leaving and you filed for the reentry permit and you got it, that helps you with the logistics of reentering. But just keep in mind that for purposes of naturalizing to US citizenship, your prolonged absence from the country resets the clock. It resets the clock for you. So if you are already on track, let's say you had already met the 5 years, 7 years in.
Yeah, I'm moderating a webinar, but I'll call you after.
So, but that's just something to keep in mind if you're gone for too long. So that's just consider naturalizing if that's an option for you.
I'm moderating Khandi and Meg's webinar right now. Can I call you back?
Sorry, Chrissy, can you mute?
There are exceptions on the naturalization and prolonged absences. There are exceptions for US military and for spouses of US citizens working abroad for a US employer or for certain qualified entities. This is called the 319B naturalization. Naturalization can be a topic. We can do a webinar on naturalization alone. So the intent was not to get into naturalization, but just to call it out for you that please be aware there's a difference between the reentry permit or the SP1 visa will help you with reentering, doesn't necessarily preserve your eligibility for naturalization. But as I mentioned a few slides ago, certain qualified people can actually file an N470, which preserves their physical presence. The time that they're gone is not held against them if you had filed an N470 ahead of time.
Khandi, thank you so much for bringing up this specific topic, because I think this is one of the things that's most confusing about preserving residency, and the thing that permanent residents sort of conflate the most. And a lot of times we will end up doing consultations with people who they thought that they were doing the right thing and planning ahead and applied for the N470 to preserve their eligibility for citizenship, thinking that that was going to protect their residency like a reentry permit would. They're totally distinct issues with a lot of confusing overlap. I mean, even sort of the numbers and the analysis, so the numbers look similar, but the analysis is different. It's incredibly confusing. It confuses immigration practitioners and immigration officers all the time. So to be completely clear, a reentry permit protects your permanent residence. That's what's going to be your remedy if you need to be out of the US and your concern is re-entering and continuing your permanent residence. If you are interested in naturalizing, then protecting your naturalization eligibility, there's really just this one narrow remedy, the N470. And in the last 13 years, I've had a total of 0 clients be eligible for this. And that's because it requires that you've spent 1 year since becoming a permanent resident, 1 full year without any travel outside the US. The issue is most of my clients who have these obligations, travel, family obligations abroad, which so many do, they don't have a 1 year period that they haven't left the US. So you also see people sort of confusing that requirement and applying for N470s when they're not eligible. So it can be a helpful benefit for the very few people that qualify for it, but it probably does more damage and confusing people than it does in really providing a broad benefit to any kind of critical mass of permanent residents. So and just to go back to the naturalization eligibility issue. So as Khandi mentioned, permanent residents you have to have been a permanent resident you have to have continuous residence as a permanent resident for 5 years or 3 years if you're married and living with a US citizen. So that basically means continuous residence is no trips abroad for more than 6 months at a time. So that's probably going to remind you of our second black and white rule, that your residency, it can be called into question and you have fewer rights upon return if you've been out for 6 months. So there's the overlap and there's sort of room for confusion there, but the 6 month breaking continuous residence has to do just with naturalization eligibility. And then there's the separate requirement, as Khandi mentioned, of physical presence. Now the physical presence, that can be, that has nothing to do with interruption of days. That's just a literal counting of days you've accumulated physically present in the US, and they don't have to be continuous. So different requirements, a little confusing, but what you really want to do, as Khandi mentioned, if you can plan ahead, that as soon as you're eligible for naturalization, you want to be thinking about applying, especially if you have obligations abroad. because that's truly the only lasting remedy for dealing with these issues. The only sort of silver bullet for protecting your status in the US is to eventually naturalize. Otherwise, you're always going to be in this, I mean, it's not technically conditional status, but the law does make permanent residence quite conditional in that you have to be maintaining it and spending the majority of your time here or applying for a reentry permit.
Yeah. And it can be really heartbreaking to hear people say, I wish I had known, I was already eligible, if only I had known. So that's the idea, is we're trying to create, you know, we're trying to build awareness. And just to state the obvious, once you naturalize to US citizenship, all these residence requirements fall away. And like I said earlier, there are permanent residents who have very good reason to not want to naturalize. In some cases, it's because, you know, their country of birth does not allow dual citizenship, and so they don't want to give up their, you know, they don't want to give up their Dutch citizenship to become, just because they're becoming a US citizen. So there are very good reasons you may not want to naturalize. But it can really be very heartbreaking when we hear people say, I wanted to naturalize and I wish I had known. So I just keep that in mind. It resets the clock. It can set you back in terms of starting the count again.
Exactly. And I will say I have had situations where I've had an individual apply for naturalization, but they were dealing with some temporary work obligations abroad or family obligations, and we applied for a reentry permit. And they still had their US domicile, which is part of the naturalization eligibility. But because they were traveling so frequently, we wanted to protect them from any issues with Customs and Border Protection at the airport. And so we ended up applying for a reentry permit just to be very conservative. And some clients are concerned that applying for a reentry permit is going to show, it's going to look like they're not really maintaining their residence, or they're not a legitimate green card holder. And it's actually the opposite. It's a layer of protection. And if you avoid it because you think it's going to look bad, you'll probably end up in a worse situation. I've never had a client who had, was maintaining their residence and being careful about, maintaining their ties to the US, and had the fact that they had a reentry permit used against them.
You're basically telling the government ahead of time, hey, I intend to come back. I'm not abandoning my residence. And sometimes, you're traveling, you may be traveling out there to, because there's a sick parent, and then you get there and things are worse than you had expected and things take a turn. So there are truly legitimate reasons why you may not have anticipated being gone for so long, but you want to just have that, take that precautionary measure just in case.
Exactly. And as we're wrapping up with the presentation part of this webinar, Khandi and I, in preparing for this, we're thinking, it's all about planning ahead, right? That is the best case scenario, that you can plan ahead, you can get the reentry permits started, you can really, brainstorm your important ties to the US, talk to an attorney about how you document those ties, maintaining bank accounts, continuing to pay your US taxes, continuing your professional licenses, continuing to get a driver's license, all of these different ties to the US, and maintaining those. And of course, doing an assessment for naturalization eligibility, which is the ultimate remedy for this. But it is really important to consider sort of a holistic approach to maintaining permanent residence. And in these sort of crazy pandemic times, when you haven't planned, to consider, what are the options? What should I choose? Should I try to re-enter the US, even though I've been out for more than 6 months? We've been doing a lot of consultations on that lately. And if you can document your ties to the United States, then you may not want to go ahead and stay abroad and apply for the SB1 visa. You may, with an attorney's advice and assistance, consider trying to re-enter the US after that 6-month mark, with really solid documentation of your ties and that the trip was extended for reasons that were outside of your control. So we're sure that people have questions, especially because this is such a confusing topic with a lot of overlap. So I think Christina is going to help us unmute. So if you have a question, if you can use the raise hand function in Zoom, we would be glad to try to answer your questions.
And you can also type your question in the chat, and Christina will monitor that as well and just alert us to any questions that you have. And I should just mention, I think I heard someone ask in the chat earlier, I saw a note saying, please post the PowerPoint to, well, I think make the PowerPoint available. It will be posted. I believe it will be posted with the webinar itself actually will be available on our website.
Yes, I'll post a recording of the webinar and a PDF of the slides on our website in the next, probably later this afternoon. So if you check the bottom of our homepage on our website, you should be able to find it there.
Thank you.
Great. So do we have any questions about preserving residence, about naturalization? Okay, so there's a question here. Oh, great. There's questions popping up in the chat. So one question is, did you say no international travel last 12 months prior to applying for citizenship? No. So that's not part of citizenship eligibility. So with eligibility for naturalization to citizenship, you have to show continuous residence, continuous permanent residence for either 5 or 3 years. 5 if you are applying, not married to a U.S. citizen. If you are married and living with a U.S. citizen, you can use the 3-year standard. And that means in that 5-year or 3-year period, you don't have any breaks in your continuous residence, and that you've had no trips abroad for longer than 6 months in those time periods, okay? And then you have to show physical presence in the United States for half of those time periods. So 2.5 years for the 5-year period, 1.5 years for the 3-year period. So at least that amount of physical presence in the US. And it doesn't have to be continuous. It's just a matter of counting the days. The 1-year thing that this person is referencing is the application to preserve continuous residence. That's the N470. And that again is this benefit that very few people are eligible for, because you have to show that since you became a permanent resident, there was a 1-year period in which you did not travel outside of the United States. And if you can show that, and it's only available to people who have certain employment abroad as well. So if you meet these different criteria, then you can apply to protect your continuous residence. So basically kind of preserve the continuous residence. So one of your trips is not going to break your accrual of 5 years of continuous residence or 3 years of continuous residence for naturalization purposes. Again, it's something that I've never had a client be eligible, and many clients have asked about it. It's a difficult, narrow benefit.
I actually have done it, but it's usually in the context. You're talking about World Bank employees, people who have very specific employment, but it just has to be carefully reviewed. It's not widespread. It's for most people, it's not. You just won't qualify. But if you have that special employment with a U.S. organization or with the World Bank, then it's certainly something that you want to at least have it reviewed to make sure that you're not eligible. But Meg is right. It's not a widespread. For most people, it doesn't apply. For some people, in very limited cases, it does.
Okay, great. And so then we have another question: prolonged absence for naturalization eligibility. How long is that? So hopefully we just talked about that. Basically, the rule is for naturalization eligibility, you break your continuous residence if you've been out. There's a rebuttable presumption that you've broken your continuous residence if you've been outside of the U.S. for over 6 months. It's a rebuttable presumption. in that if your trip was over 6 months but less than a year, you can provide evidence to USCIS that you had access to your home the entire time, that it was a temporary trip, and prove that you maintained your US domicile during that time period. When I have clients in that situation, they've been out for maybe if it was a 182-day trip, then maybe we would try and push it and rebut the presumption. Other clients will probably choose just to wait and apply for citizenship once they're fully eligible and don't have that break, and can apply it in a more straightforward manner. It just depends on the urgency of the application. If the person can wait, then it's a more straightforward process. If they can't wait, then maybe we would try and push it and rebut the presumption they've broken their continuous residence with that one trip.
So I saw two questions, and Christina, if you could just, for the benefit of everybody, maybe read out the question, or maybe Meg and I would try and read out the question. One
Sure.
question here was on naturalization. Are we going to have a training? We've noted the interest, and we will. I cannot promise because we don't have it on the schedule yet, but we've noted the interest on a naturalization presentation. I think somebody also asked the question. I saw one fly by that if you apply for a reentry permit, can't you then try and come back, before every 6 months, just to break your absence? I guess we go back to the rules that Meg started with. You may be able to meet the letter of the rule, but then they'll always look through intention. So the reentry permit, yes, does protect you as far as intention, because you were saying ahead of time, just in case this takes longer than a year, or maybe I know already that this is going to take longer than a year. I've been posted to, it's a job assignment, it's a 2-year job assignment. So I know I will be gone for 2 years. So I know that ahead of time, then clearly, you're protected. But if we really caution against the just coming back just in the nick of time, because whereas the reentry permit may help you, it helps you overcome the presumption that you had abandoned your residence, but you still have to be very careful about just, if you were using a reentry permit and coming in every 5 to 6 months. Meg, do you want to weigh in on whether that could be an issue?
Yeah, I mean, I think generally speaking, if you've had if you have, you're on your first, second, third, or fourth year on a reentry permit, I don't think you're going to have a problem. I think Khandi makes a good point in that it's not a cure-all, and there is some case law with people who've been deemed to have abandoned their residence because they were on reentry permits for 8, 9 years, 10 years, and had zero ties to the US. So you can't, that's why you really want to look at the reentry permit sort of in sort of a comprehensive plan of preserving residence, and you do want to keep those ties as well and reenter as frequently as you can manage. I think that when I've had clients going abroad on a reentry permit who also want to maintain their citizenship eligibility, I have suggested that they do come back within 6 months of every departure. So they don't break their continuous residence requirement for naturalization. Now, it's important to remember that even if you're doing that, you're still going to have the physical presence requirement for naturalization. So that still might be fine. I think it's always good to strategize for that way. Once you return to the US, then you really do need to make sure that you've accrued the appropriate amount of days, half of the required time period, so half of 3 years or half of 5 years in the United States. But yeah, I've definitely developed those sort of plans for clients. Get the reentry permit, maintain your ties, and then with an eye towards applying for citizenship in a few years, make sure you protect your continuous residence and come back within 6 months of every departure.
And I should mention something we should have actually mentioned before we started. We should have mentioned it at the outset or before we started the Q&A section of this presentation. We are addressing questions, but of course, this is not considered legal advice because, you know, to get proper legal advice, we need all the facts and you have to sit down with an attorney and not necessarily sit, maybe Zoom with an attorney and have your questions answered. So this is all general overview information, just throwing that disclaimer out. Just to jump onto something that Meg did mention, intention is really important. So when we throw out the term, don't, you know, as long as you're not, your conduct has to be consistent with being a permanent resident. So there are some things actually that you could do that could jeopardize your permanent residence. So for instance, you could do all these things, but if you travel abroad and then you're filing taxes in a foreign country as a resident of that country, you cannot in the same breath say, I'm maintaining my US permanent residence. So you could do all of this, but the proverbial, the devil's in the details. It depends on what exactly are you doing. There will always be room to look at your intentions, your purpose of the absence, and have you done anything to jeopardize that residence, such as filing taxes as a resident of a foreign country.
Great. So Khandi, we've got a really good question here, and we touched on this a little bit. Can you apply for a reentry permit while your application for naturalization is pending, or vice versa? Would being out of the country affect naturalization in this case? So traveling and being abroad during the naturalization process is kind of an interesting issue. People can travel while they're naturalizing, while their application, their N-400 is pending. They also don't have to be physically present in the United States at the time the application is filed. It's sort of an interesting fact. Unlike the reentry permit, you can file while abroad. But what's so critical about naturalization is that the person meets the jurisdiction requirement. And they have to have a US address, their actual domicile, and they have to have lived there in the USCIS district where they're going to be submitting their application. They have to have lived in that district for at least 3 months. So if you are living in a US, if you meet that requirement and then you go outside the US, you have to come back to that same jurisdiction. You have to come back, you have to stay within that jurisdiction. If you don't, then your application is going to be moved and transferred and eligibility would become more complicated. So I always tell my clients, yeah, you can travel. You can even, you know, if you had to take a flight for a work trip and we're about to file your application, we can still file it while you're gone, but you really do have to have a genuine domicile in the United States, and you have to meet that jurisdiction requirement. Let's see, are there any other questions that we haven't gotten to?
The only one I see that wasn't addressed was from Barrett Enga.
Yeah, I see that. It says, I have a green card, left the US for a summer vacation, but decided to stay on for kids to be in school in Norway, as their school in the US was closed, and it was announced while we were away that it would continue to be closed due to COVID. We will return after the 1-year mark. What is best to do?
So that's a great question. And I think this is a very common scenario right now. And if I were to consult with this individual, I would say you need to be looking at the SB1 returning resident visa. If you've been outside of the United States for over a year without a reentry permit, then that green card is no longer going to be a valid travel document for reentry. And again, of course, there are a couple of exceptions for US military and certain crewmen. I don't see any, I don't see those facts here. Of course, we'd want to do a full assessment. But yes, if you've been outside of the US for over a year with no reentry permit and you don't meet any of these different exceptions for, you know, for sort of special treatment, then you should absolutely consider the SB1 returning resident visa. It's important to remember, if you try to re-enter on a permanent resident card after 1 year, what will likely happen is that Customs and Border Protection will find it to be an invalid document, and you will face the prospect of either being refused admission and forced to leave, or being paroled into the United States for removal proceedings. And during these removal proceedings, you will have to prove your case that you maintained your residence. That is an incredibly stressful and time and resource intensive process. Definitely nobody wants to go through removal proceedings. So, a sort of smarter plan of action would be to apply for a returning resident visa. But as Khandi mentioned, we really want to be careful about giving specific legal advice. So this is, we're providing this as sort of a general assessment. And for any specific guidance, we encourage you to contact us or another attorney with experience in this topic.
I know we're coming to the end. I do see one more asking, how can I apply for an SB1?
So you apply for an SB1 visa at your the U.S. consulate or embassy that's closest to where you're living abroad. And as I mentioned before, actually, if you search SB1 visa and your U.S. embassy, you'll find specific instructions on how to follow through with that process. But it does start with the DS-117, filling out that form and gathering the documentation to show that you're a permanent resident when you left the U.S., that you have a continuous uninterrupted intent to return to the U.S., but that your stay abroad was prolonged due to circumstances outside of your control. And again, COVID is to me, a great example of a circumstance outside all of our control, for which we're not responsible, that is prolonging many, many people's return to the United States.
And on that note, we should also mention that, these things are consulate specific right now in terms of which consulates are operating at full capacity. I'm not sure any are operating at full capacity or at limited capacity, limited hours and so on. Although it does, things like an SB1 visa for permanent residents, that would be a priority. Just check with the consulate, the US consulate in the country in which you are about timing. But certainly, yes, that's the kind of thing you need specific guidance on.
Khandi, that's an excellent point. And I also do want to point out that during a recent State Department and American Immigration Lawyers Association liaison meeting, there was a question about returning resident visas. And essentially the question is, can you make this sort of an easier process or sort of give people more of a pass and allow them to return, maybe after 2 years instead of going through the SB1 process? And the response from the Department of State was essentially, we're not changing our policy. So the policy remains, you need to apply for an SB1 visa if you've been out for that amount of time. So unfortunately, we're not really seeing any sort of announcement of them facilitating the process. But as Khandi mentioned, I think that the best way to approach this is to check the embassy or consulate's webpage, see if you have a way to contact them and request how to begin the process. And of course, this is something that we are also, this is something we do for clients as well.
So we do have one, what might be our final question here about specifically how all of this impacts naturalization. We're asked, still unsure what is expected when you apply for naturalization, but due to COVID are stuck outside of the country and can't come back. I understand it affects reentry, but would being over 1 year out of the country affect your naturalization application?
So the answer to that is yes.
Yes.
If you've been outside of the U.S. for over a year, that is a break in continuous residence. It's not rebuttable, and the individual would have to wait. You basically restart the clock. The regulations say that after a break in continuous residence, you have to wait 4 years and a day, or 2 years and a day, depending on whether you're applying under the 5-year or 3-year standard to reapply. The USCIS policy manual has sort of amended that, and they want you to wait 4.5 years or or 2.5 years after a break in continuous residence to apply for naturalization. So it does, that kind of a prolonged absence is really going to restart the clock for continuous residence purposes.
So I think with that question, we're at the end of our time. Meg and I would really like to thank everyone who signed up. And like Christina said, this will be posted up to the website. So it will be available, the PowerPoint and the webinar itself will be available for, on the website. Thank you so much for signing up. And we're going to sign off now. Thank you.
Wonderful. Thank you. Thank you, Khandi and Christina. And thank you everyone for participating in all of these great questions. We hope this was helpful.
Thank you so much. Thank you.
Thank you. Thank you.
Thanks, everybody.
Thank you.
Thank you.
Happy Friday.